Okay, we are doing a video on contracts in the state of Georgia. My name is David Blanton. I am a pre-licensed instructor in the state of Georgia, and this specific video is to help you understand contracts better in regards to pre-licensing. I'm not an attorney. You should not be using this as legal advice. This is just to help you get your license in Georgia. The project lifecycle, offer to execution. So, phase one is the formation of the contract. The formation includes the offer, any counter offers, and then when we finally come to a meeting of the minds or agreement. Now, when we say a meeting of the minds, please understand it has to be a meeting of the minds on every point of the contract. Nothing is too small of a detail to not be agreed upon. And so if there is anything left that is not agreed upon, we do not have a contract, period, point blank. Then we have the executory gap. And so this is when we're doing all of the work to get the deal closed. So we're going through financing, we're getting an appraisal, we're getting an inspection, the title company is pulling title, right? All of those things are happening during this executory gap. That's why if you want to buy a house, it takes you, honestly, we can probably get it done in 12 to 14 days now, but most of the time we're putting 30 days or so onto the contract to get everybody plenty of time to get the deal done. And then we get to the execution or collapse part of the contract. And so this is at the closing table, promises turn into final actions, discharging the contract. And it says, unless a structural breach causes the deal to collapse. Now, if either party doesn't act within the contract, it is a breach of contract. Also note that given that we have contingency periods in most contracts, a buyer could be denied financing. As long as they have a financing contingency, they can terminate the contract, get their earnest money back. They don't have a breach. They didn't breach anything. They're just terminating the contract due to basically a contingency in the contract that would allow them to do so in the case of certain circumstances. All right, now this right here, I don't love this particular graphic. And the reason why I don't love this graphic is there's an acronym that I like, and it's CALL, C-A-L-L. And this is what's required for a valid contract. Okay? And so the C is consideration. The weight exchange, mutual exchange of valuable assets or promises, e.g. property for money. Now, I do want you to understand, it has to be valuable consideration. It does not have to be equal consideration. In other words, if there's $1 million property and I get the owner to write a contract for $200,000, that would be totally fine. That would be a valid contract because it has valuable consideration. And so don't get confused on valuable to think that it needs to be equal. Next, we have competent parties. Okay? And that's the first L. Okay? They have to be legally competent. All signers must possess the legal capacity to be bound. So what does that mean? Well, that means that you have to be over 18 and you cannot have gone to court and had a judge say you are legally incompetent. Then we have legality of purpose. Okay? The contract's objective must not violate statute or public policy. So I like to use some ridiculous examples just to drive the point home. If I hired somebody to kill somebody, right? I know you guys have probably all seen Law and Order or other cop shows, and they had the quote unquote contract killer. Well, if I hired somebody to kill, Bob, and I hire Steven to kill Bob, and Bob's supposed to be gone by Monday. And Monday comes and there's Bob. He's still alive. I couldn't very well go to court and sue Steven and say, Your Honor, I paid this man $50,000 to kill Bob. He didn't kill Bob. I either want him to kill Bob or give me my money back. So we can see how that's an absurd example, but it also illustrates that it has to be legal. Okay? If a contract isn't legal on its face due to zoning, statutes, public policy, anything like that, then it is not a valid contract. In fact, it's a void contract. It doesn't exist. All right. Mutual assent and reality of consent. Okay, so those are both in the A, basically the A letter up here. Mutual assent means we have meeting of the minds on every single point of the contract. Again, there is no point too minor. If the buyer wants a general warranty deed and I'm only going to give them a limited warranty deed, then we don't have a contract even if we've agreed on every single other thing. Now, reality of consent is a little bit different, and we'll be getting into that as we go along, but the structural integrity decisions are made of free will, absence of fraud, duress, or fatal mistakes. Okay, I don't love the word fatal there. I guess it just kills the contract. And we'll talk about these kinds of things, but it's kind of like if you were to sign a contract while you're drunk, well, when you sobered up, you may say, oh my gosh, I would not have signed that contract if I weren't drunk. And so that becomes a voidable contract, which we'll talk about here in a minute. Now, I don't love that 6 is in here. Okay? Now, it is correct. The statute of frauds is required for there to be an enforceable contract. And here's the rub. A valid contract may not be enforceable, but all enforceable contracts must be valid. And so the statute of fraud says a contract has to be in writing to be enforceable. That's 100% true. You need to know the term statute of frauds and know that statute of fraud just means that it needs to be in writing. That's all it means. Sometimes the quizzes or the tests will give you these really super long, like the statute of frauds exists to prevent fraud and blah. Nope, it's just everything has to be in writing. But here's the rub. I could have an oral contract with somebody else that has all the components of call, consideration, assent, mutual and genuine, legal purpose, and legal competence. And if I have all of those, then it's a valid contract. Now, don't misunderstand. If both parties didn't proceed, there would be nothing that you could do to enforce it. But there is a distinction between enforceability and validity. And so validity just requires valuable consideration, mutual and genuine assent, lawful purpose, and legal competence. Okay. Let's clear those drawings and move on to the next part. So the contract status diagnostic matrix here, valid, 100% binding, all 6 elements present. Again, that's 5 elements because technically it doesn't have to be in writing to be valid. And then both parties bound. Okay, both parties bound. It's bilateral. Both parties have agreed to be bound by the contract. They both made promises. Now, void, dead on arrival, there is no contract. It could be an illegal purpose or somebody who's already been declared legally insane. Okay, and it has no legal force for anyone. Now, I want you to understand that if we have an offer, it's a void contract. If we've sent over an offer, it's a void contract. If the seller counter offers us, then the offer that we sent is now void and they have sent us a new offer. Okay, they've declined our offer and they've sent us a new offer. Now, we'll get more into void as we go along here. Voidable, compromised but alive. It could be fraud, duress, minor, intoxication, so under the influence of drugs or alcohol. And then the injured party holds the key. Here's the thing about voidable. The injured party, so when we talk about injury, right, we're talking from a legal standpoint. So somebody who is under 18, somebody who is declared legally incompetent after we go under contract, somebody who has been basically a victim of fraud, whether that be actual fraud, which is when somebody tells you something that's wrong, or negative fraud, which is when they hide something that's wrong from you, whether you've had menace or duress, so the use of force or the threat of force, whether you've had Innocent misrepresentation, which, by the way, I could accidentally tell you something that's wrong, but if you're depending on it to buy the property, you could absolutely decide that you wanted to rescind the property due to innocent misrepresentation, even though I didn't do anything intentionally wrong. And then unenforceable. See, this is why I don't like the statute of frauds being included in the valid part of things, because it's still valid, but unrecognized or unenforceable, right? Oral agreements, statute of frauds, neither can force court action. One thing that's missing here, okay? One thing that's missing here is statute of limitations. Statute of limitations. So understand that, yes, if it's not in writing, it could be unenforceable, but it could also be unenforceable due to the statute of limitations. Statute of limitations. And that just means that the time period is too far for us to go back and enforce the contract. Okay? The time period, the time elapsed is too much for us to go back and enforce the contract. And so that too is unenforceable. Doesn't mean it's not valid. It just means it's unenforceable. All right. Void. Primary triggers of void structures. Unlawful purpose. So contracts requiring illegal acts, e.g. financing that exceeds maximum FHA limits, forged instruments, zoning violations, etc. Adjudicated incompetence. Now, this part is key because it says previously declared mentally incompetent. Previously, I underwrite the wrong part there. Okay? So if they were declared legally incompetent or mentally incompetent prior to signing the contract, then it is a void contract. The nuance here is that if they were to sign a contract and then be adjudicated to be incompetent, at that point it would be voidable. Okay? And then mutual mistake of vital facts, an agreement lacking mutual assent on every detail, e.g., both parties are mistaken about the actual parcel of land being sold, which sounds ridiculous, but I actually had that happen once when we were in the middle of the foreclosure crisis. I had somebody, we found a property, I think it was a 5-bedroom, 4-bath house, and it was listed at a stupid cheap deal. And so we immediately put in an offer, we won the bid, and while we were going through title, the attorney called me and he said, David, the address that you have on here and the legal description that you have on here isn't the correct property. It turns out that the listing agent that was working for the bank listed the house right next door. They were both foreclosed, but they were owned by two different companies. And so she listed one that was vacant, had the locks changed, everything, but she actually listed the wrong property. And when talking to her, it wasn't her fault. The lender sent her the wrong property. Okay, so again, that is a mutual mistake. My person thought they were putting an offer in on property A when they were actually putting an offer on property B. And the seller thought that they were selling property A when they were actually selling property B. And so that is a mutual mistake. Therefore, it is not valid. But not only is it not valid, it is 100% void. Now, void can happen for a lot of different reasons. I never get notice of acceptance. You send back acceptance, or you accept the offer and notify me after the time limit of the offer. That's a void contract. If we haven't agreed to everything on the contract, that's still a void contract. If I've sent you an offer and I change my mind and I rescind the offer, that's a void contract. Okay, so there are, and if we're negotiating and one of us dies, that's a void contract. Okay, so again, there are a few different ways for it to become void. I won't say become void, I'll just say there are a few different things, if present, make the contract void or make there be no contract. Because the absence of a contract is a void contract. And a void contract is the absence of a contract. All right. Voidable, the structural escape hatch. A voidable contract contains all essential elements, but one party was subjected to a disability or improper action. The contract remains completely valid and binding until the injured party chooses to pull the lever. Okay? And so in this situation, the offender is bound to the terms, cannot force cancellation. One of the, and I don't love that it says the offender here, because I'm going to use an example that I don't think it's necessarily an offender, but it's one example that I see a lot on tests. A person who is under 18 rents an apartment. The landlord finds out that they're under 18 after they've already signed the contract. Can the landlord terminate the contract? The answer there is no. The landlord cannot terminate the contract. Again, this is all academic. This is all pre-licensed. We could have an argument of how the landlord may try to do it in real life, but per the test for this class, academically, no, the landlord cannot terminate the contract or rescind the contract because the tenant is under 18. But the tenant being under 18 would absolutely allow him or her to rescind the contract without any consequence. Okay? Now, the injured party holds the exclusive right to rescind, cancel, and recover value, or to ratify, proceed, and make the contract permanently binding. Now, when we go to the right blurb there, the time limit, action must be taken within a reasonable time, otherwise the law considers the contract legally ratified. There is this idea of intention. And so let's say that I put a house under contract and we've got a 45-day closing, and the day before closing, so it's been 44 days, I send the form that says I'm rescinding this contract because I was drunk at the time that we signed it. Well, here's the reality. The judge, because the other party can take me to court and force me to prove that I had the legal right to rescind it, the judge is probably going to look at me and say, were you drunk the entire time from the time you put the house under contract until the time, the day before closing? Because if not, this doesn't count. Because if you sobered up 40 days ago and you're just now deciding to rescind, well, you had 40 days where you intended or showed that you intended to ratify and move forward. And so that's what we're talking about, the time limit of the action. Now, there is no number of days that you need to know. It's a reasonable time, and a judge would determine that. Okay? A judge would determine that. All right. Now, deception and force. So this is actual fraud, which is malicious misrepresentation or concealment of material facts. Okay? Now, I would add negative fraud to that box, because concealment of material facts is going to be negative fraud. Okay? Actual fraud is you're lied to. Negative fraud is that the truth is hidden from you. Then we have duress or menace, use of force or threat of injury to compel agreement against free will. And then we have undue influence, exploiting a relationship of trust for unfair advantage. So the example that I always give, and by the way, the test question is usually going to say something like an elderly woman was depending on their, great nephew or grandson. It's usually an elderly woman being taken advantage of by a younger male on the test, just from what I've seen. Doesn't mean it has to be that, but it could be that. And the way that I explain it is, when I was selling cars, I worked for a local company, and I had a manager who was a little less than ethical. And my wife and I had moved to Georgia in October of 1997, and I was working for this car company, and my in-laws had a transmission go out in one of their cars, and we had just gotten a car in on trade that was beautiful. It looked really, really clean. It was a Buick, had super low miles, And we only paid like $4,000 for it. And so I went to him and I said, hey, look, I know that we have to get some sort of something for the car and we need to make a little bit of profit, but is there any way that my in-laws, because basically they were saying they were going to, put it on the lot for $10,000 or $9,900. And I said, is there any way my in-laws could buy it for like a very moderate profit? And he put his arms around me, and I'm not going to use the words he exactly said, but he basically said, David, if you can't screw your family, who can you screw? And that's what that undue influence is, right? We all know that our families and our friends and family often will trust us more than strangers. And sometimes we may use that relationship to our advantage or to take advantage of somebody. And that would be what undue influence is. All right, quadrant 2, accidents. Innocent misrepresentation, which is just an honest mistake of material fact relied upon by the buyer. So I coach agents, new agents, and one of the agents that I was coaching had a property. She was working with the seller, and they had a survey that said it was 100 acres. But the survey was from like 1950 something. It turns out that the county had come and taken part of the land for roads and highways and right-of-way and all of those things. So now they had 96 acres. Well, when they listed the property, they listed it as 100 acres because they believed it was 100 acres. The buyer got a survey, and the survey came in at 96 acres. And so they had to renegotiate. Okay, they had to renegotiate the deal because the buyer could walk away, because even though the seller genuinely believed it was 100 acres, the reality is it was no longer 100 acres. And then we have constructive fraud. Now, unintentional negligent misrepresentation by someone who should have known. Constructive fraud is typically going to be, constructive fraud is typically going to be a real estate agent, an attorney, a mortgage company, something like that in terms of the test. And so constructive fraud might be something like a real estate agent showed a property and thought it was zoned commercial. When further research was done after going under contract, it was discovered that it was zoned residential. Well, in that situation, and here's the key, the agent has to believe what they're telling them, but what they believe to be true turns out to be not true. Okay? What they believe to be true turns out to be not true. Now, another word for this, they actually use right here in the definition. So you'll see constructive fraud or negligent misrepresentation. And again, it is negligent because you should know better, right? It is negligent because you should know better. And so you should never tell somebody what the zoning of a property is unless you have double checked the zoning of a property. All right, then quadrant 3 is diminished capacity. So minors, again, anybody who is under 18, the contract is always voidable, always voidable, always voidable. And only the party who is under 18 can rescind the contract. Okay? Contract is voidable at the minor's option up until a reasonable time after reaching majority, which means 18. And again, reasonable time is for judges. I don't get to make that decision. You don't get to make that decision. And we don't have to have an idea of what a reasonable time will be for the test. Intoxication. Voidable if signed under the influence, requires action promptly upon achieving sobriety. So what's interesting is I had a client come in from New Jersey, and we spent 2 days looking for a house for them, and we finally found one on the second day, and we'd been out all day. I hadn't even had breakfast. I don't think they had had breakfast, but it was like 6 o'clock in the afternoon, and we had been out since like 9. So it had been a good 7 hours. And they had a Mexican restaurant right next to their hotel, so we're like, we're going to go in and celebrate and put this offer together, and it's going to be great. And we had a picture of margaritas. And what's interesting is theoretically, they could have argued that they could have rescinded the contract because they were under the influence of alcohol while signing the contract. Okay? Now, alcohol is one thing, but it could be prescription medication. It could be illegal narcotics, like just anything that would alter your ability or anything that would basically get you a driving under the influence kind of a ticket could be used here to rescind the contract. Okay. All right. Sorry, I need to delete these lines. And turn off that. Yep. All right, moving right along here. Okay, unenforceable. The missing blueprint. An unenforceable contract may be perfectly valid between the buyer and seller, but the courts will not recognize it or enforce it. To prevent fraud and failed memories, like who hasn't been told something and agreed on something and had somebody say, oh no, that's not what I said. Georgia law dictates that all contracts to buy, sell, or lease real property for more than a year. So the lease is for more than a year. Must be in writing to be enforceable. By the way, that is a key point that you want to have a good handle on. The statute of frauds says that if a lease is for more than 1 year, so that means 366 days or more, it must be in writing to be enforceable. An oral lease or a verbal lease up to 1 year, so up to 365 days, is still enforceable even if it's just oral. And the way that the question often will say is, when does a lease have to be in writing? Or when can a lease be oral? And they'll do it this way. So when does a lease have to be in writing? The correct answer is when the lease is more than 1 year. Another answer that they're going to give you that you have to watch out for is when the lease is 1 year or more. And I know that sounds like the same thing, but it's really not, because one is saying it can be exactly 1 year or more than a year and it has to be in writing. And the other saying only if it's more than a year. And the right answer is only if it's more than a year. And then it could say, when can a lease be oral and still be enforceable? And the right answer is 1 year or less, but they could also throw in there less than 1 year. So again, pay attention to that. And the other thing about the test, all of the words matter, so pay attention. All right, oral real estate contracts might be valid if both parties are willing to perform or willingly perform, but if a dispute arises, the court will refuse to intervene. And then we have the parole evidence rule. Written terms absolutely supersede any prior verbal negotiations or promises. If it's not in the contract, it doesn't exist. Okay, if it's not in the contract, it doesn't exist. So, quick example, I had a client who was buying a home, and they did the inspection, and the seller was there during the inspection, which kind of stinks, but I wasn't able to be at the inspection because I was with my daughter in the hospital, and I had another agent attend, and the other agent didn't intervene as much as I would have preferred, but stuff happened. And every time that the inspector found something, the seller said, I'll fix it. Every time the seller said something, or the inspector said something, the seller said, I'll fix it. Now, here's the deal. When I talked to my buyer, I said, well, let me write all that up and I'll get it over to the other agent and we'll get the seller to sign it. And my buyer said, look, I don't want to have him sign it. He said, I'm afraid that I'll offend him. He seemed like an honest guy. And I just, I think it would be the wrong move to put it in writing. And I said, okay, well, obviously I represent you. I'm going to do whatever you want me to do, but I have to make sure you understand that if he refuses or doesn't do any of the things that he promised you orally or verbally, there is nothing we will be able to do about it. And if you're comfortable moving forward like that, then we can move forward like that. And he said, okay, great, let's move forward. Now, it worked out great for him because the seller was also a contractor and not only fixed everything that was found by the inspector, but actually did some stuff. Like while he was fixing it, it was like, oh, I don't like the way that looks, and would just like redo the whole thing. And so my buyer made out perfectly. And my buyer read that guy 100% correct. And who knows if he would have done everything if we had asked him to put it in writing. But here's the deal. If we hadn't put it in writing and the guy hadn't done anything, we would have had to close on that house and there would have been nothing that we could do. Right? All right. So, executory contract. Both parties are actively in the process of fulfilling mutual promises. Buyer duties are applying for loans, conducting property inspections, securing funds. Okay. Now, seller duties, maintaining the property. They have to maintain it in the same condition or better. Okay, the same condition or better as of the time that you put it under contract. I had a seller one time, and I'm not sure why, but basically moving out got left until the last minute. They're trying to move out literally the night before, and they lose their footing. They fall down the stairs, and they're carrying a dresser, one half of a dresser, and they literally go all the way through drywall into the half bath. And so I'm checking in on them, bringing them pizza, just checking to see what's going on. And I see the hole, and I was like, oh my gosh. And he's like, am I going to have to fix that? And I was like, well, yeah, because the contract says the property has to be delivered in the same or better condition. He's like, well, don't people expect some bumps and bruises from moving? Okay, well, first of all, maybe, but that's not really a bump or a bruise. That's like a complete hole in the wall through two pieces of drywall. And honestly, I don't think he went to sleep that night because he was able to get the drywall fixed and painted, and it was fine. All right, risk of loss. Oh, sorry. Curing title defects and ordering termite bonds. Okay, curing title defects, ordering termite bonds. Now, I'll also say this. If we've done an inspection and the sellers agreed to do any kind of repairs, then they need to do it during this period. If it's on a septic tank and we asked for a clear septic letter, again, they're going to need to do it during that period. And usually the contract will have specific dates that all of that stuff has to be done by. Okay. Risk of loss. If the property is substantially damaged during this gap, the buyer can typically rescind and recover earnest money or proceed and claim insurance proceeds. All right. That's a little incorrect. And so what I mean by that is most of the time, yes, the buyer can, because remember, the property has to be delivered in the same or better condition the same condition it was when they put it under contract or better. And so if there's a significant damage, the seller may not be able to get it repaired before closing. And so the buyer can walk. Now, the buyer may not be able to close if the damage is significant unless it's a cash deal, because if it's not a cash deal, if they're getting a mortgage, the lender probably won't loan on the property. And if it's been damaged after the appraiser looked at it and they didn't let the lender know, that would be a type of mortgage fraud. Okay? And so I feel like that's a tad bit misleading, but you kind of understand what's going on here. Okay? The other thing under buyer, and it's not something the buyer does, typically it's typically something the lender does if they're getting a loan. The lender has an appraisal done, right? And an appraisal is different than an inspection. An inspection is solely for the buyer. The inspection is to let the buyer know what possible issues there are with the condition of the property. The appraisal is technically just for the lender. Yes, it can protect the buyer. That could be a side benefit of it, but it's not the primary benefit. The primary benefit of an appraisal is to protect the lender, right? To protect the lender so that the lender doesn't loan more on the property than they should. All right, executed contract. The transaction is complete. At closing, mutual promises transform into definitive actions. Time is of the essence. A critical clause making the exact dates in the contract strictly enforceable. Without it, dates are merely reasonable expectations. All right, the exchange, the buyer delivers the purchase price, which is the legal tender or equivalent. The seller delivers the general warranty deed transferring marketable title. And in Georgia, that typically happens at the closing. We don't typically close in escrow here. I know some states you close in escrow, and it could be 20 or 30 days until the transaction is complete. Here, when we go to the closing table, we are closed. The buyer gets the keys, the seller gets the money, and we get paid too as real estate agents. All right, survival. Generally, contractual obligations merge into the deed at closing and cease to exist unless a specific survival clause dictates otherwise. Okay? So there has to be a specific clause in the contract that says that something survives. So I'll give you an example. I was helping one of my clients buy new construction. Part of what we had negotiated was them getting a garage door opener in the garage, which is where you would put a garage door opener if you didn't know. And when we go to do the final walkthrough, the garage door opener is not installed. So I bring that up to the builder, and the builder writes out an IOU that basically says we'll install the garage door within 14 days from closing, right? And on that specific sheet of paper, it says that these items survive closing. Because if we don't have it specifically outlined that things are going to survive closing, they typically won't. Okay? They typically won't. Now, the exceptions could be fraud, misrepresentation, that kind of thing. But if it is generally, the idea is that if the buyer elects to close on the property, then any conditions in the contract are deemed to be complete. Okay? Some exceptions, but for the most part, that is the way that the test will look at it. All right, structural failure, breach of contract. A breach is the non-performance of a contract without a legally acceptable excuse. When a party defaults, the injured party suffers a financial loss and holds the right to legal recourse. Okay? So, condition precedent. A required prior action failed, e.g. seller refused to fix the roof as stipulated, legally excusing the buyer from purchasing. Okay? So there was a condition in the contract that was not met, and the buyer was able to terminate. Supervening illegality, a sudden change in law makes the contract's purpose illegal. Typically on the test, that's going to be that they're using eminent domain to condemn the property. Okay? They're using eminent domain to condemn the property for public use or benefit. Well, as soon as the county, city, state, whatever says, hey, we're going to be condemning the property, then our contract is now illegal. Our contract is now illegal. All right, waiver. The injured party voluntarily chose not to enforce a specific contractual provision, permanently losing the right to demand that performance. Okay, in the real world, we talk about mutual termination. Okay, mutual termination. And that's when, and you can always mutually terminate any contract. It's when one party and the other party agree that they don't want to continue forward. That's mutual termination. Okay, that's mutual termination. And there may be financial compensation for that mutual termination, but once we all sign the mutual termination and move past it, then neither party can enforce the contract. Okay, or a specific provision or anything like that. All right, rescission. The rewind mechanism cancels the contract and returns both parties to their exact legal and financial positions prior to signing. The result, the buyer recovers the earnest money deposit, often achieved through mutual agreement to avoid court. Okay? Damages, compensation. So liquidated damages, a pre-agreed sum serving as total compensation for a default. In real estate, the seller usually retains the earnest money as liquidated damages if the buyer breaches. Sue for actual damages, a court lawsuit to recover exact monetary losses caused by the default. All right, so in terms of damages, and earnest money specifically, so there's a concept out there that earnest money is required. It is not legally required. You can have a valid contract without earnest money. Earnest money is not part of the valuable consideration, if you will, okay? And so we don't have to have earnest money to have a contract. And in most contracts, the earnest money is liquidated damages, okay? And so I remember I had a client, I listed their house. It was a cash buyer. It was going to be, and it was a kind of an older rundown house. It was an estate sale. And basically the buyer, it was buying it for like $100,000, was just going to push the house down and make a parking lot for his hotel that was adjacent to the property. And what was interesting was, there's no set earnest money amount. We often see that earnest money is around 1%, 1.5%, something like that. And so he put up $1,000 earnest money. I actually went to closing with my seller. And even though most times in Georgia, you'll have both parties with the closing attorney, when you have a commercial client, sometimes and technically this was residential, but the guy buying it was going to be using it for commercial, so he handled his side kind of like a commercial transaction. I had already given the seller their closing gift, taken a picture for social media, congratulated him, and then on my drive home, the attorney that was working our side calls and says, hey, the buyer's not going to close. Now, the buyer had more than enough money to close. He was going to be paying cash for it. We had already seen that he had basically a bank statement that showed proof of funds that he could pay cash for it. And he just decided not to close on it. And there was nothing we could do because the contract, most standard contracts say that the total compensation that the seller will receive is the liquidated damages or the earnest money. Okay. Now, I could have sued for my commission. That's a different section. But as far as the seller goes, the only money that they can get is whatever the earnest money is or any other liquidated damages. By the way, one quick thing. I wouldn't have been the one suing the buyer, right? My broker would be. I don't want to confuse you. The broker is the only one who has the legal authority to bring a lawsuit against somebody for commission. All right, then liquidated damages can also be for a buyer. So if you look at a lot of new construction contracts, most of the time there's a way for the seller to terminate the contract and pay liquidated damages. So like $250 or $500. And that means that even though we quote unquote have a binding contract, the seller can often just terminate the contract, write you a check for a very small amount of money, and turn around and resell it to somebody else. When we were in the ridiculous seller's market and things were going up due to inflation and cost of materials, there were a few transactions that I was in where I was fighting to keep my buyers in not fighting my buyers, but fighting the sellers to keep my buyers in the transaction because they were new construction contracts and basically the seller just wanted to pay us, I think one was $500 and one was like $250 or $400, something like that. Want to just write those checks and then turn around and sell the property. And they had the contractual ability to do it, and so we had to negotiate through that. All right, sue for actual damages, a court lawsuit to recover exact monetary losses caused by the default. That's typically going to be on the buy side, not the sell side, because the sell side is usually limited to liquidated damages. Now, if there's no liquidated damages clause in the contract, then the seller could sue for actual damages. Specific performance, and this is the enforcement. Now, typically specific enforcement, or specific performance, I should say, is something that they ask a question about when the seller refuses to sell the property. And what I mean by that is we have it under contract for $300,000 and a new development went in and now they think their house is worth $400,000, or somebody came and offered $400,000, or they got an appraisal for $400,000. Whatever it is, the seller doesn't want to sell it to us for the price that we had it under contract for. Well, at that point, you would sue for specific performance, a court order legally forcing the defaulting party to complete the transaction exactly as written. Okay? Because real estate is considered unique, non-homogeneous, or non-homogeneous, courts frequently force sellers to hand over the specific property rather than just paying a monetary fine. Okay? And so when we talk about specific performance, we're typically talking about a buyer suing a seller for specific performance. And again, this is an academic more than reality concept in terms of my experience. But if you got a question that said the seller was under contract for 200, now wants 300, or was under contract for 300, now wants 400, what would you do? It could say something like, well, walk away, have it reappraised, negotiate. And those may be things you do in real life, but for the purposes of the test, we're always looking to exercise our maximum legal authority, which would be to sue for specific performance. All right, so this is kind of it in a summary. Does it have the 6 essential elements? Again, that's 5 essential elements. The 6th one is statute of frauds in writing. It's technically not an element to be valid, but it is an element to be enforceable. Okay, so it could fail due to lawful purpose or competency. That means that it's void. And by the way, when it says lawful purpose, it means that it would be illegal, right? It could fail reality of consent. That would be voidable. I would also say that up here, it could fail mutual assent or mutual consent. And when we look at that, that means that there's some part of the contract that isn't agreed on, right? The is it in writing, that's actually one of the 6 essential elements that they gave us, even though it's only 5. If it's not in writing, it's unenforceable. That doesn't mean it's not valid. It just means that it's unenforceable. Then, as long as we've got all those things, valuable consideration, genuine assent, mutual assent, lawful purpose, legal competence, then it becomes, yes, valid and enforceable. And then we proceed to the phase executory gap. So those are all the pending conditions. And if we have a default or a breach, okay, then it will trigger remedies, rescission, damages, specific performance. And if everything goes according to plan, we see full performance, which is an executed closed contract, and the property is sold. All right, so that is an overview of contracts.